Welcome back to the deep dive. We are pushing further into our MPP series.
Yep, deep into the manual.
And today, we're zeroing in on something, well, pretty specific, but really important strategically. Chapter 1800, the Patent Cooperation Treaty, or PCT.
Right, and within that, our focus is MPP Section 1895.
Section 1895. So what's the core topic here?
It covers how you file a continuation, a divisional, or even a continuation in part, a CIP application here in the U.S.
Okay.
But specifically when you're starting from an international PCT application that designated the United States.
Right. Okay. Now, that sounds a bit different from the usual route people talk about for bringing a PCT into the U.S., doesn't it?
Mm-hmm.
Isn't the standard way the national stage entry under 35 U.S.C. 371?
Exactly. That's the standard path. But this section, 1895, it deals with what's often called a bypass application.
A bypass. Interesting term. So how does that work?
Well, instead of using that 371 national stage process, Section 1895 explains how you can use the regular U.S. national filing system under 35 U.S.C. 111A.
Ah, the normal way you'd file a brand new U.S. application.
Pretty much. You use that 111A path to essentially continue prosecution directly from the international application. It's a distinct procedural choice.
Okay, so our mission for this deep dive.
Yeah.
Let's figure out why someone would use this bypass route. What's the legal basis for it? What are the, absolute must-do requirements? And any practical tips? Ready to unpack it?
Let's do it. So, first things first, you got to understand how the U.S. system even sees a PCT application from the get-go.
Oh.
Under 35 U.S.C. 363, if you file a PCT application and it designates the U.S., the law treats it as if it were a regular U.S. national application filed right here.
On its international filing date.
Exactly, on its international filing date.
Wow, okay. So the moment that PCT application exists and points to the U.S., it's kind of like it's already got a U.S. application number pending, legally speaking. That's pretty powerful.
It really is. And that status, that 363 treatment, it continues as long as the international application is considered pending.
And how long does that last?
Generally, it stays pending until one of two things happens. Either the applicant formally withdraws or abandons it internationally, or, and this is key for the bypass discussion, it becomes abandoned for U.S. purposes because the applicant didn't enter the national stage the standard way under 371C within the deadline.
Okay, so that pending status is the window of opportunity. While the PCT is still technically alive internationally, or at least not dead for U.S. national stage purposes, that 363 status applies.
You got it.
And that's what lets you do the bypass. Because filing under 111A connects back to that as if U.S. application status.
Precisely. You file a new U.S. application under 111A, calling it a continuation, divisional, or CIP of that still pending international application.
And that lets you claim the PCT's filing date.
Yes, under the usual rules for claiming benefit to earlier applications. That's 35 U.S.C. 120 for the domestic relationship aspect, and 35 U.S.C. 365C, which specifically connects U.S. applications back to PCT applications.
Got it. So the legal bedrock is 363, giving the PCT that initial U.S. status, and the mechanism is 111A filing using 120 and 365C to claim the date. Makes sense. So what does Section 1895 say are the absolute must-haves to make this bypass work correctly?
Okay. MPP 1895 really boils it down to three critical requirements. Non-negotiable if you want that earlier date.
Right. Lay them on us. Number one.
First, and this is super important, the bypass application you're 111A filing must be filed while the parent international application is still pending.
Copendency. The applications have to exist at the same time, even for a moment.
Exactly. Copendency is key. You can't let the PCT fully expire for U.S. purposes and then try to file the bypass. The timing has to overlap.
So watch that 371 deadline clock. If you miss it, the PCT might be abandoned and the bypass window closes. What's requirement number two?
Number two is about the inventors. There needs to be at least one inventor in common.
Meaning?
Meaning at least one person named as an inventor on the new bypass application must also have been named as an inventor on that parent international application.
Okay, that makes sense. It establishes the chain, the connection between the applications based on who invented it. And the third requirement, I have a feeling this one involves some tricky details.
You'd be right. The third one is that the bypass application must contain a specific reference to the parent international application.
Not just mentioning it somewhere, it has to be a formal, specific reference.
Yes, very specific. It's how you officially tell the USPTO, hey, this new application is related to that earlier PCT, and I'm claiming its filing date. It's not optional.
Okay, specific reference. What exactly needs to be in that reference? And are there like deadlines for putting it in.
Oh, absolutely, there are deadlines, and they are serious. The rule covering this is 37 CFR 1.78.
1.78, got it.
Your reference, usually in the application data sheet or the first sentence of the spec, needs to clearly state three things.
What are they?
1, the application number of the parent PCT application. 2, its international filing date. And 3, you have to explicitly state the relationship continuation, divisional, or CIP.
Application number, filing date, relationship type. Seems straightforward enough.
It is, but here's the kicker, the really critical part. Submitting this reference has strict, non-extendable time limits defined in that same rule, 37 CFR 1.78.
Non-extendable. Uh-oh. That sounds like zero room for error.
Exactly. It's one of those deadlines in patent law where if you miss it, you generally can't fix it later by saying it was unintentional or paying a fee. Missing the deadline to properly claim benefit under 1.78. That can kill your claim to the PCT filing date.
Wow. Okay, so that reference isn't just paperwork, it's a time-critical step. So the three pillars from 1895 are copendency, common inventor, and that specific timely reference under 1.78.
That's the core framework.
So let's move into the next section mentioned, MPP 1895.01. What practical stuff does that add?
Yeah, 1895.01 gives a bit more practical guidance, helps flesh out some scenarios. For instance, it clarifies how the Patent Office figures out if that parent PCT was actually pending when you filed your bypass application.
How do they determine that?
Well, for most PCT applications filed on or after April 1st, 2002, it's pretty clear-cut. The international application is generally considered pending for U.S. purposes until 30 months from its earliest priority date.
30 months from priority.
Right. Unless, of course, the applicant explicitly withdrew it or abandoned it earlier. But that 30-month date is the typical drop-dead date you need to file your bypass application before to ensure that copendency we talked about.
Okay, so that 30-month mark is usually the finish line you're racing against. What about older applications? You mentioned a date change.
Good point. For PCTs filed before April 1st, 2002, the rules were different. The deadline to enter the national stage was often only 20 months from the priority date.
Ah, much shorter.
Yeah. So if you're dealing with one of those older cases and you filed a bypass application based on it, say at month 25, you might actually need to provide extra proof to the USPTO.
Proof of what?
Proof that the international application was still considered pending under the old rules when you filed your bypass. This might mean showing you filed something like a demand for international preliminary examination and elected the U.S., which could have extended its pendency back then.
Ah, okay, so the history matters. And you might need documentation to prove pendency for those older cases. It gets complex.
It can.
Now, you mentioned continuations in part, CIPs, a few times. Is there a particular reason the bypass route is especially relevant for those?
Yes, absolutely. This is probably one of the biggest strategic reasons to choose the bypass route over the standard 371 national stage entry.
Why is that?
If you need to file a CIP because you want to add new subject matter stuff that was not in your original PCT disclosure.
Like new experiments, new embodiments.
Exactly. If you need to add that new material, you must use the bypass route under 35 U.S.C. 111A. You cannot do it through the 371 national stage entry.
Wait, really? You can't add new matter when you enter the national stage. Why not? It feels like you should be able to update it.
It's a fundamental difference in how the procedures work under U.S. law. Entering the national stage under 371 is seen as just transitioning the existing international application into the U.S. examination phase. The rules flat out prohibit adding new matter at that point.
Okay.
But a bypass application filed under 111A, it's treated more like filing a regular new U.S. application even though it claims priority. And standard U.S. practice allows adding new matter in a CIP.
But the new matter doesn't get the old date, right?
Correct. You only get the benefit of the earlier PCT filing date for the subject matter that was disclosed in the PCT. The new matter gets the filing date of the CIP itself. But the key is the bypass route lets you add it.
That is a massive difference.
Yeah.
So if your invention evolved or you realized you needed more supporting data after filing the PCT, the bypass is basically your only option to get that new stuff into a continuing U.S. application while keeping the link back to the original PCT date for the old stuff.
That's the long and short of it. It's a crucial strategic distinction.
Okay, what about foreign priority? Say the original PCT application claimed priority to an earlier patent filing in, I don't know, Germany or Japan. Do you have to claim that again in the bypass application?
Yes, you do. Another potential pitfall here. Even if the parent PCT document lists those form priority claims under 35 U.S.C. 119 A through D,
You still have to list them yourself in the U.S. bypass application.
you absolutely must expressly make those form priority claims again in the new 111A bypass application. You can't just assume they carry over automatically because they were in the PCT.
So you're making two claims, really. The benefit claim back to the PCT itself under 1.78 rules, and any foreign priority claims the PCT relied on under different rules.
Exactly. Both need to be explicitly stated in the new bypass application. And like the PCT benefit claim, these foreign priority claims also have deadlines for submission.
Are those deadlines also non-extendable?
Here's a slight difference. The deadline for submitting the foreign priority claim under Section 119 is governed by 37 CFR 1.55. While you should always aim to submit it on time, if you miss that deadline, there is a possibility to restore it under 37 CFR 1.55, generally if the delay was unintentional.
Okay, so a little bit more flexibility on the foreign priority claim timing compared to the absolute brick wall of the PCT benefit claim timing under 1.78.
A little bit, yes. But still, best practice is always file everything correctly and on time. Don't rely on fixing things later if you can avoid it.
Yeah, definitely sound advice. So wrapping this section up, MPP 1895 and 1895.01 really map out this alternative strategic path. The big picture benefit seems to be flexibility while keeping that crucial early date.
That's a good way to put it. You retain the benefit of the international filing date, which can be huge for prior art purposes, but you gain procedural options you just don't get with the standard 371 national stage entry.
And those options include potentially amending the disclosure more freely, maybe restructuring claims significantly, and that really key one, being able to file a CIP to add new matter developed after the PCT was filed.
Exactly. It's a powerful toolkit.
But it sounds like a toolkit where you need to read the instructions very carefully. Missing one step, like that non-extendable 1.78 reference deadline,
Can make the whole strategy fall apart. It really highlights how these procedural rules, while complex, offer strategic pathways if you navigate them precisely. Attention to detail and timing is everything here.
Well, this has been a really illuminating deep dive into MPP Section 1895 and 1895.01. It clarifies a pathway that might not be the default, but clearly has significant advantages in certain situations, especially with CIPs.
It definitely shows how understanding the nuances in the MPP can open up important strategic choices for applicants.
Thank you so much for joining us and walking us through that. And listeners, thank you for tuning in. We also want to give a special thank you to Mike Shepard for organizing this entire audio series.
Yes, thank you, Mike. And now, please pay close attention to the disclaimer.
This summary of the MPEP was generated using AI tools and may contain errors or omissions. It is for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction.
For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.
And as a final thought to leave you with today, think about this bridge between the international PCT system and the national U.S. system that Section 1895 represents.
Yeah, these rules aren't just bureaucratic hurdles. They're complex mechanisms designed, maybe intentionally or maybe evolved over time, to give inventors strategic pathways.
Pathways to manage their inventions as they develop, even after that initial international filing. Consider that balance, the complexity of the rules versus the potentially invaluable strategic options they unlock for protecting innovation globally.
It's a trade-off between procedural burden and strategic freedom. Something to think about.
Definitely something to ponder. Until our next deep dive, thanks for listening.